Well, hello everyone. Welcome to the series Mud Talks, Basics of Patenting Your Ideas with Shelly Fujikawa, class of 98. My name is Vanessa Chu, Assistant Director in the Office of Alumni and Parent Relations. We thank you for attending today's event. This talk is being recorded and will be distributed only to those registered after the event. Please feel free to type your questions in the Q&A box, not the chat, and we'll try to get through as many questions as possible. Now, I'm going to turn over to our speaker to introduce herself. Shelly, the floor is yours.
Okay, great, thank you. I'll put on my slides here. Okay, hello everyone. My name is Shelly Fujikawa, and today I'm going to talk about the basics of patenting our idea. But before I start, I wanted to do two things. First, I'd like to give a disclaimer that what I'm going to give you is some general advice and no specifics. So there's not going to be any attorney-client privilege attached to the information that I'm giving you. And then the second thing I wanted to do before launching into my talk is just talk a little bit about how I came into patent law, because it's kind of a non-traditional scientific pathway, just in case there are some students out there that are wondering how it came to pass. So I graduated with a degree in chemistry in 1998. And then from there, I actually went to the Netherlands for a year on another Netherlands American fellowship. And I studied medicinal chemistry at Leiden University. I came back to the US after the year. So in 1999, I started my PhD at Harvard in the lab of Jaap Schafstack. And then in 2003, I graduated. And at the time, I wasn't really sure if I wanted to do a traditional academic or industry path for myself. And I was thinking that find alternative careers. So in the world of alternative careers, there's patent law, there's some scientific writing as well. And so I decided to apply to some firms up and down the East Coast, because at the time they were really looking for people with a scientific background to be able to interface with scientists. And in particular, they were looking at biotech companies and pharmaceutical companies. So I landed my very first job in New York, and I was in the position of scientific advisor. And so the way, at least back in 2003, they were really wanting newly minted PhDs. And so they would send you to school as after working for a year at the firm. So I went to work for this firm called Darby and Darby. I worked for a year, and then I started school at Fordham University on Manhattan. So I went to school at night, and then worked during the day as a patent agent. I took the US PTO patent bar. And then after 4 years, I graduated and became an associate at Darby. And then the rest is history. I did take a couple years off to take care of my kids in the middle, but now I'm back doing patent law. So I wanted to just give you that brief introduction. So I'm with a firm called Libra IP Law. We're a virtual firm. We've always been a virtual firm. We've been around for about 10 years. We do only patent, trademark, and copyright prosecution and preparation, meaning that we get people patents, trademarks, and copyrights, and give advice, opinion work as well. But we don't do any litigation. Our shop is just not set up for that kind of work. So I wanted to first give you an outline of my talk. First, I'm going to go into a broad discussion of intellectual property, and then narrow it down to a discussion of patents and discuss what is patentable, which in the past 10 years or so has become a very hot topic. Then I wanted to give you some things to think about prior to filing your patent application, and then go into kind of the nitty-gritty details, hopefully not too much detail, but some details about how to file a patent application and what's involved. And I know that there were some questions about filing internationally, so I can go into that a little bit more as well. Okay, so what is intellectual property? So I'm sure that you've seen many of these things just in your day-to-day life, right? So it's products of the mind. So inventions, literary and artistic works, designs, names, it can even be a color. And then those ideas of the mind, products of the mind, are defined in certain categories, right? There's things that the government gives you, like patents, trademarks, copyrights. And then there are things that are kept secret, right? Trade secrets. And with the things, especially with the property that the government gives you, they're limited in time and scope and enforceability. I guess even trade secrets are. So that's just kind of this broad overview of what intellectual property is. And I wanted to go into a little bit of policy about why intellectual property is limited. So the US Constitution actually set up patent law, and it's in Article 1, Section 8, Clause 8, and it says that Congress shall have the power to promote the progress of science and useful arts by securing for limited time to authors and inventors the exclusive right to their respective writings and discoveries. So right, there's a keyword for limited time. So the founders realized that in order to promote scientific advancement, they needed to make those scientific advancements public. But they also realized that inventors needed, most times, wanted something in return. So they thought, we'll give them a limited exclusive right to do so that in exchange for putting their ideas out there. And so that was the balance that they struck. We will give you an exclusive right in exchange for you sharing your idea. And this idea of what is limited and how much time you should give exclusivity is still being debated today. And in fact, like for the COVID vaccines, there's a suite of patents that protect those. And there's a lot of discussion on how much and whether or not those should just become public domain or not. So as I said, there were different forms of intellectual property, and I thought I'd run through those briefly. So in patents, there are a few different flavors of patents. There are utility patents. So those are the ones that you, I think, traditionally think of as patents. So they discuss the utility of whatever you're patenting, your widget or your method. And then there are design patents, and those are purely protecting the ornamental features of, it's usually a thing, like a consumer good. And then there are these special patents called patent patents that protect new hybrids or new varieties of an apple or a flower, for example. There's also trademarks and trade justice. I'm sure you're familiar with the symbols, word marks, logos, phrases. It can be a color like on your tube of toothpaste. The Colgate red is trademarked. And then there are copyrights, right? There are novels, writings, artistic works, sound recordings, video recordings. Trade secrets is something that's also protected under law, under federal law. And that's where a company or a person has decided to keep their idea secret and not apply to make it public in like as a patent or as a design. And there you have, so for an example, like the Coca-Cola recipe is a famous trade secret, as well as the KFC, the Kentucky Fried Chicken recipe. Those are both trade secrets. Excuse me. There's also what's called industrial designs. They're very similar to design patents, except kind of the equivalent in the rest of the world. Someone asked, I think, a question about can you use more than one of these types of intellectual property to protect a certain item? Absolutely. So for example, like a consumer good, oftentimes you would see a utility patent for its functionality, a design patent for how it looks, since it's usually consumer good has some kind of recognizable feature. And then the trademark, trade dress would protect it. Software use is protected by utility and design patents as well. In the past, I guess, they've been protected by copyright, but not so much anymore. Pharmaceuticals, which is the area that I practice in, or the technical expertise that I practice in, they use, it's almost exclusively utility patents and then some trademark as well. So why would you want to protect your idea rather than keep it a trade secret? So they kind of those reasons fall into two buckets. One is monetary, and the other is the idea of excluding others from practicing your invention. And I guess this is more towards oriented towards the patent. Why would you want to protect your idea in the form of a patent? So there's the economic incentive. Of course, your patent could be worth millions or billions of dollars, and that could happen. But more likely is that you're looking for funding from venture capital. So if you go in front of venture capital and say, hey, look, I have this application, or hey, look, I have this patent, it gives you more credibility, I think, in the eyes of venture capital, that you're doing something inventive, that there's a third party that's looked at your invention and said, hey, there's novelty and inventiveness for this idea. The other aspect of the monetary prong, I guess, is that oftentimes you can use patents and your patent estate and your trademark estate as assets for an early stage business to get capital to expand your business. So the other prong is that oftentimes you have to protect your idea prior to going out and publicizing it, right? Not everyone will sign an NDA. You might not want to sell your product without a patent because it's easily reverse engineered, so that a trade secret won't be sufficient. And then there's the idea that once your idea is public, it is very, very hard, or sometimes impossible, to patent it. Okay, so what is a patent? And I'm going to read the first bullet point, and then I'll discuss a little bit some of the aspects of it. A right to exclude others from making, using, or selling a product that embodies what is defined in the independent claims for at least 20 years from the earliest non-provisional filing date. Right, so the 20 years, right, that we talked about that, it's a limited, your right is for a limited time. So what is your right, though, is a right to exclude others. So it's not a positive right, it's actually a negative right, a right to exclude others. And I'll, in a couple following slides, might be the next one, I'll talk about why it's a negative right and not a positive one. And then the claims, that I'll talk about that in a couple bullet points. So there are 4 categories of patents. There are processes, manufacture, machine, or compositions of matter. And a patent itself has a structure that's kind of similar to a scientific journal article. It includes a title, a background, a summary, and then a detailed description, which really is the body of your patent application and your patent. It describes in very great detail, hopefully very great detail, about your invention. And then examples, which would be the equivalent of materials, methods, and data in a scientific journal article. And then figures or drawings for like a mechanical application. Your drawings would show your widget. And then figures would be like you would find in a scientific journal article if you were presenting data. And an abstract. And then the last part, which differs definitely from a scientific journal article, are the claims, right? And that defines what you're able to assert, like in a patent infringement case. So I have some example claims, and there are two different types of claims. There are independent claims and there are dependent claims. So claim one is my independent claim, and it claims a jelly-filled donut. And that defines the invention that I'm trying to protect, right? The jelly-filled donut. Claims 2 and 3 are called dependent claims because they depend from claim 1, and they further define the jelly-filled donut or the invention. So in this case, they define the type of jelly that my donut has. Okay, so this is what I discussed about. It's a negative right. So having a patent does not give you the freedom to practice your invention. There's a concept called a dominant patent, where an earlier patentee has broad claims that would prevent you from practicing your invention. So for example, in the idea of your jelly-filled donut patent, right, the claims to a jelly-filled donut, if someone earlier has claims to a donut, that patent would be a dominant patent, preventing the person owning the jelly-filled donut patent from practicing the patent. And that sounds very kind of harsh, but in some cases, things kind of work out. So you can think about a situation where you have a company that has this jelly-filled donut patent, but in their previous research, they received a patent on candy bars, right? All candy bars. And then you had a second company that has this patent on donuts, right? But they're now really interested in candy bars, and they got a patent on nougat-filled candy bars, right? But they know that you have a patent on all candy bars, which is preventing them from practicing their nougat-filled candy bar patent, right? So you can potentially, one company can approach the other and say, look, I have a patent that you want, you have a patent that I want, can we make a licensing deal? And so even though these dominant patents seem very draconian, oftentimes something can be worked out so that everyone can do the research that they want to do. I thought I'd talk very briefly about patentable subject matter. This topic could go on for hours. And as I said at the beginning, this topic actually has become very, very important in the last 10 years. Prior to that, people really didn't talk about what is patentable and what is not. So I thought I'd read the statute that everyone points to concerning patentable subject matter, and it's in 35 U.S.C. 101. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof may obtain a patent therefor, subject to the conditions and requirements of this title. So that seems very, very broad, right? Process, machine, manufacture, composition of matter. And it was up until about 10 years ago, but there was, the Supreme Court put a judicial exception on this section. And what it said was, we don't want to allow the patentability of basic tools of scientific and technological work. So the Supreme Court had made a policy decision that they didn't want to make pure tools of scientific and technological work patentable because they didn't want to discourage other people from doing that scientific work. So there are things definitely that are indisputably basic tools, right? Gravity, electromagnetism, math, calculus, arithmetic, things like that. They're very black and cut and dry. This is definitely a basic tool and can't be patented. However, there are many, many things that are not as black and white. So, for example, abstract ideas, laws of nature, and natural products have become very controversial on what is patentable and what is not. Abstract ideas come into play for software applications and patents quite a bit, business methods as well. And then laws of nature and natural products are in the areas that I practice in the pharmaceutical, biologics, and chemical arts. So I thought I'd go into a couple cases about that so you kind of get a flavor of this uncertainty, right? What is a basic tool and what is not? So the first case is this 2003 Supreme Court case called Molecular Pathology versus Myriad, and it has to do with natural products. And the Supreme Court made this very bright line rule that said genes are unpatentable. Genes that you would find that you could sequence from the human body are unpatentable, whether or not they were isolated. And prior to this time, you could isolate a gene and patent it. And the Supreme Court said, no, 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 you can't do that. Genes are unpatentable. But they did go on and say that synthetic complementary DNA, so cDNA, is patentable. So if it has only coding regions, it's patentable. And so people started to think, well, started to wonder, well, what else is not patentable? Like, how different do I have to be from a natural product? Certainly, you can't isolate a natural product, it would be patentable. But what happens if I just added a single carbon onto it? Would that be patentable? So there's a lot of gray in what is patentable for a natural product. The other significant case, at least in the technologies that I practice in, is laws of nature. And that case is a 2012 Supreme Court case called Mayo v. Prometheus, and it has to do with diagnostics. I'm going to talk about a later case that I think is a little more, to me, it's a little more instructive. And it has to do with this company called Sequenome. So Sequenome came up with this law of nature. They discovered this law of nature where they found that if you drew maternal blood, there was some fetal DNA in that blood when the mother was pregnant. So, and they could test the blood of the mom and say that figure out the gender and if there were any genetic abnormalities in the fetus. And so this was great. It reduced the amount of amniocentesis that had to be done on pregnant women. And so Sequenome patented it, they got a patent, and someone challenged them in court. And what the court said was this process, this method that Sequenome had patented, had nothing new other than this law of nature that Sequenome discovered. All of the tools that were being used, like PCR and sequencing, those were all known and widely available to one of ordinary skill in the art. And so they disallowed this diagnostic patent, and so they found it not patentable. And so that really, I think, upset the balance of how much funding is going into diagnostics right now. So as you can see, there's a ton more that I can talk about with patentable subject matter, but I should go on so I can get to more topics. But if you have any questions about that, you can feel free to ask me at the Q&A or also offline as well. So just generally, I wanted to talk about pre-application writing and what you need to think about. So it's important to think about your invention and what is absolutely necessary for it to work. Is there one particular thing that you must have? And then what is optional? And also, what are the ranges of what is optional? And maybe your absolute necessary thing can have, there's a preferred embodiment that it works the best versus something that might be, there's a range for, maybe it works maybe just a little bit less well, or there's a range in which it doesn't matter what it is, it will just work in that range. Oftentimes when I work with inventors, I think there's this misconception that having less detail in your application, in your detailed description as part of your application is better. But to me, within reason, of course, having more detail and more description about your invention is better. And the reason why is that when you have to correspond with the US Patent and Trademark Office about your application, and there's some back and forth about what the scope of your invention and what's patentable about your invention, the more detail you have in your detailed description is going to help you, has been my experience. The other thing that you want to think about for writing your application is the data that you have. And this is particularly important in the chemical and biological arts, and also for pharmaceutical applications. It's, I would say, almost unheard of not to have some sort of experimental data accompanying your application, in those arts. Inventorship is another aspect that you want to think about. In the US, whoever conceives of the invention are the inventors, and they are the ones that initially own that application or that invention, right? And then there's an assignment that flows from the inventors to the assignees. It's usually a company or a university that allows the company to gain ownership of your invention. So inventorship isn't something that is, I guess, decided by some arbitrary decision, right? It is definitely like who conceives of the invention, and so there's a definition to that term. Oh, so this is kind of my public service announcement, what not to do before filing. And if you avoid these things, it will make your life, and if you have an attorney, if your attorney is helping you, their life a whole lot easier. So avoid public disclosure of your application, of your invention, right? So, and avoid sales, avoid offers for sale, avoid private offers for sale and private sales, and then avoid public use. And I know that sometimes it's super hard to do that because you need funding, you're trying to drum up some business, but it is, if at all possible, try to avoid those things, because after you make something public, maybe not, there's some rules that protect you in the US, but abroad it's very, very difficult and most likely impossible to file an application after you do these things. So the other aspect of pre-application writing is searching. So there are two major types. There's patentability searching and freedom to operate searching. So patentability searching is just what you would expect. Is my idea patentable? So you can usually you can do it yourself or you hire a firm to do it, but search what is out there in the prior art, including applications, patents, publications, what's on the internet, for whether or not your idea is patentable. The second type of search is called the freedom to operate search. And this goes back to the idea of a dominant patent. And it looks at the area that you're you're trying to get your patents in, and sees what else is out there. Does anyone else have a dominant patent on the close to your idea that will prevent you from practicing your idea, right? And then it also is a useful tool if you know that your area of practice is very, very crowded, right? And then you can look at, well, you know that you want to go into this area, but you can look for white spaces where people haven't done the science or investigated or filed an application on, and it's a means to direct your research, and also it's used to determine what kind of products that you want to market. So this is one of my very last slides, and it's actually a very dense slide. So I can talk about this slide quite a bit. And I know, let's see, there was at least one question about, I think there were two questions about international filings that hopefully I can answer. So when you're getting ready to file an application, there are basically three types of patent applications that you can file. You can file a provisional application, a US non-provisional application, or a PCT application. Traditionally, like a solo inventor would file a provisional application and then decide whether or not they wanted to pursue a US non-provisional application and or a PCT application. Okay, so a provisional application you can think of as a stake in time. Whatever is written in your provisional application will get the date that you file, and it's proof that you had that idea at the time of filing, right? It's relatively inexpensive compared to filing other types of applications. It lasts a year, so it expires after a year. So it doesn't mature into a patent, but it does defer costs and provides time. So oftentimes an inventor comes, they have an idea, they aren't sure whether or not it's going to be feasible for them to pursue it, to actually make it, to commercialize it, but they just want something on file to show that they thought of that idea before anyone else. So they file a provisional application. You might have heard that you can file anything as a provisional application. You can file something on the back of a napkin. You can file an abstract. You can file a manuscript. You can file a website. I've seen all of those done, I think, other than filing an idea on the back of a napkin. And that's certainly possible. You can get an application serial number from the USPTO. However, there is the downside that whatever your invention will be defined by what is in what's written, not what is in your mind still. So what we counsel people to do is to make that provisional application as complete as possible, because that will give you your stake in time to show that you have rights to that invention prior to anyone else, right? So in my final slide, I'll discuss why that is so important, and kind of hopefully it's another public service announcement that why it's so important to have such a complete application. So going back to, you filed your provisional application, and after a year, you have to make a decision. Do you want, on whether or not you want to continue to pursue that application? So you have two different decisions. Do you want to just file in the US so that you only have US rights, or do you want to file what's called, do you want to file for foreign rights? And oftentimes the mechanism for doing that is a PCT application. You can also only file a PCT application and still get US rights. So we can talk about the PCT application first though. So after a year, let's say as an inventor you decide that you only want to file in the US. So you file a US non-provisional application, and 1 to 4 years from filing, you hopefully get a patent. The downside is it's more costly, definitely, than filing a provisional application, because not only do you have to pay for filing costs, but you also have to pay for correspondence with the examiner at the U.S. Patent and Trademark Office. So that's in the case of a U.S. application. Now, if you're thinking about my application and my invention could be valuable in other countries, most times you file a PCT application, and that is will allow you to enter national phase or enter other countries besides the U.S. It never matures into a patent, but it gives you the right to file applications in various countries that will mature into patents in various countries. So the way that works is a PCT application is filed, let's say 12 months, it must be filed 12 months after the provisional application, and then another 18 months after, you have another 18 months to figure out where you want to file internationally prior to having those costs. So it's a good way to conserve or to defer costs prior to determining where you want to file internationally. And so when at the end of those 18 months, you have to decide where you want to file. And most of the time, by then, inventors have decided either this is a great idea, I can go and file internationally. Hopefully they've received some funding because international applications and filing internationally in individual countries can be quite expensive, especially if you do 2, 3, 4, 5 of them. So from a PCT application, you can go into Europe and then Asian countries, China, Japan, Korea, Canada, Mexico, most any country that you can think of. The exceptions, there are some countries that are not part of the PCT, and common countries that are not part would be Taiwan and some South American countries. Let's see. So this is my last slide, and I just want to go back to why it's so important to file a well-written provisional application. So there's a couple scenarios in which an inventor doesn't disclose details that are important, that are in their provisional, that should have been disclosed in their provisional application, and then they go out and decide to disclose it maybe at a conference or on their website, and then after a year they decide to file a non-provisional application and a PCT application, but they're barred from filing from obtaining foreign rights because they've disclosed their invention outside the provisional application within the year that they filed the provisional application. And there are special laws in the US that prevents them, that will not bar them from obtaining US patent rights, but foreign rights are a little less forgiving. The second scenario has to do with a third party disclosing details that are not disclosed in your provisional application after you file. In that case, if you were to try to file either a US or international application, both applications would be rejected because of this third party disclosure. So it's really, I wanted to stress that it's really important to file a very complete provisional application, or as complete as possible, because of these pitfalls. So that's the end of my presentation. And I guess I can look at the questions and answers, or Vanessa, did you want to?
Sure, we have a few questions for you. Let's see. So it used to be that a patent was granted to the person who could prove first invention. Am I right that it's changed? So now it's granted to the first one to file.
That's right. So it's like 2011, it changed.
Great, thank you. Our next question, do you have any advice for small businesses that are not venture capital funded about how to hire professional help with a utility patent application if you only have a budget of $5,000 to $10,000?
So that's definitely, it depends on the type of application, but generally like for consumer good, I'm thinking like a simple mechanical application, $5,000 to $10,000 can get you a decent application. Maybe not at the big firm, big law firms, but at a smaller firm with good infrastructure to help with the filing, $5,000 to $10,000 is definitely doable for a mechanical application. It's less doable if it's a more complex, let's say, software application or biotech or chemical.
Great, thank you. Our next question, so if you're a current MUD student or just students in general with limited time and money but have a working prototype, what is the best path to take to protect your idea?
I don't think, well, I think it depends on who funded your idea. So if it's through MUD, I'm gonna guess that MUD has some rights to it. And I don't know, actually, I don't know if there's a technology transfer department at Harvey MUD or the 5 colleges or not. But that's definitely something to look at. I know that up here, I'm in Seattle, the University of Washington, they have a technology transfer department that will help guide you in, because usually, so the university likely has rights in that case. I don't know about your particular invention, but at the University of Washington, if you're working in a lab with a professor, then the university owns that invention, and then they will help you write an app, or they have patent attorneys who they hire to write your application and to file it for you. If it's just like an individual inventor, that's more of, you have to at least find the funds to hire someone, or do it yourself even. It's possible. It takes more time and research to do it.
Great, thank you so much. Our next question, is it possible to work in patent law without going to law school?
It is. So you can take a test called the patent bar. And I think there's study materials. And so after you take it and pass it, you become what's called a patent agent. And you can correspond with the patent office, sign documents, counsel clients. Things you couldn't do is you could never become, well, in most states, you can never become a partner at a firm, and you couldn't do litigation. So it's definitely possible. It's just, it's limited, so.
And as students, would you be able to get an intern working with patent law?
It's possible. We right now, I mean, it's possible. It's definitely, I've been at firms where that's possible. We here haven't had a student, but you never. I mean, like next summer is 9 months away. So if you're interested, you can contact me, and I can definitely. If we can't help you, I might be able to point you in the right direction of someone who could.
Great, thank you. And then a follow-up question to that, how early should these students be reaching out to people for internships?
I think probably, I'm not sure about that. I think it's probably timed with when the law students start to get their summer internships, summer jobs, start doing that. And I think that is like I want to say in the winter, but yeah, I would start maybe when you start doing you're looking for other internships. Yeah.
Okay, great, thank you. Next question regarding software patent. Can I patent a new user experience method, whereas each individual technological components are not new inventions? In other words, the user experience is built using existing technology.
Okay. Vanessa, I think, is Dave Robertson on this? So I'm not my technical expertise is not software. And so I can answer general questions and then, of course, specific about my technology. But I have one of the other shareholders at the firm who is a software guy. I had him come on. Dave, you're muted.
I'm here.
Hello, Dave.
So you want an answer to that question in how many minutes? Seriously, that's a very good question. The short answer is no. And the reason it's no is because the Federal Circuit, as guided by the Supreme Court in certain cases, has decided that in order for a computer-related invention, meaning software, to be patentable, it has to overcome the methods that are performed, the functions that are performed. It has to overcome the hurdle of being deemed abstract. In order to overcome that hurdle, the computer has to perform something that is a technical solution to a technical problem, and not just using conventional computing. And more recently, there was a Federal Circuit case who decides patent law in the main. There was a recent case that deemed that user experience was not alone enough to overcome software patenting for abstract ideas. I would just say, if you are considering patenting software, it is possible. It does require some interaction with a patent attorney who's familiar with the patent law in this area. And certain protections can be done, and they often is something beyond the user experience that can be used as the invention.
Great, thank you, Dave.
Thanks, Dave.
Our next question, we have someone who's worked on projects at various companies that they know have been submitted for a patent, but haven't heard anything more about them. They've tried to look them up, but haven't found them. What is the best way to look up a patent or a provisional patent?
So I guess it sounds like this person might have a serial number attached to it, but honestly, I would contact if they have someone at that company. And maybe if they've already left, it might be that they made that application not public until it issues, in which case it's going to be super hard to find that application before it issues. If they already have a serial number, yeah, if the application is published, it's a lot easier to find that information. You can Google it. You can Google patents, and then use something called TARE on the USPTO website that will allow you to look into the progress of your application. And if that person wanted to contact me, I can help them out if that's what they're interested in. Yeah.
Great, thank you. What might be your best advice for approaching patenting an idea that is based on technology, which are either yet to be developed or learned about? In other words, if your idea outlines a concept which modern technology has no necessary means of approaching, how might you go about patenting such an idea?
It sounds like it's not quite right for patenting yet, because you need so part of, not only does your idea need to be novel and inventive, it has to be enabled. So you have to know how to make and use your idea. And so I guess at this point, I would caution against patenting it. I mean, you could always write a provisional application and then it never gets published. So once it kind of matures, once you have a better idea of that idea, it might be worth pursuing a non-provisional application on it. But that would be, I think at this point, well, whomever wrote that question, they're welcome to contact me to discuss it, because I don't want to discourage you to patent it, but I don't want to give you too much hope either.
Great, thank you. Our next question, does private offers for alpha testing of invention consider disclosure if there's no money exchanged or leased?
So there's, actually read an article about this today. It's this whole area of experimental use and what is considered experimental use. And there's like, I don't know, 13 or 11 different things that the courts look at to determine whether or not something is experimental use versus what is public use, and you're barred from patenting it. So things like, was there a non-disclosure agreement signed? Was money exchanged? How did the inventors view this this use? How was it described when they were discussing, like in emails, like if there was a contract? How is it described in a contract? What other? So those are the types of things that the courts look at. I would say it's definitely something to think about when you're trying. Let's say you have a prototype that you're not sure if it works, and you need to have some testing, like keeping that as private as possible without money exchanged is a good policy. But you'd want to talk with someone with that expertise to just understand the situation better.
Great, thank you. Our next question, I've heard that the US has a grace period where patents might be able to be filed up to a year after an invention was disclosed at, say, an academic conference. Is this true?
It is true, yeah. So the US, unlike pretty much every other country in the world, is very pro-inventor. So they give the inventor some slack. But if you're intending to file anywhere else in the world, it's good that disclosure is going to become a problem. And also it's having that, it is possible under the right circumstances, but I would discourage it because it just makes, it can make obtaining a patent a lot more difficult.
Great, thank you. So we're coming up on our hour, so I have time for one more question. Our last question today will be, if you're applying for a utility patent for an invention which can be constructed in multiple ways, can all the variations on the construction be protected with the same patent? If so, how should the inventor indicate the different possibilities in the application?
Okay, so yes, you can file just one application, but it's and then within your detailed description, right, you can think of it as like units. Like, I'm going to discuss this first and then the second, and it's possible if it's all connected. You can file an initial application, initial non-provisional application, and then file what's called continuations off of that application to maybe, so it in the during examination, let's say you write a claim to one aspect of your invention and then a second aspect of your application, the examiner might say, I only am going to examine aspect A and not B. And then in which case aspect B has to be, in most cases, that aspect gets canceled from the claims and you pursue and hopefully obtain patent protection for aspect A. And then prior to that initial application issuing, you can file a new application called a divisional and pursue idea B. Oh, and I should add that sometimes you don't want everything in the same application. Sometimes there are strategic reasons why you just don't want to. So it's definitely something there are nuances that you want to think about.
Great. Thank you, Shelly. Thank you, Dave. I want to thank both of you for joining us today and for sharing your knowledge and insights with us. Thank you to our audience for your questions and for attending this event. We will follow up within the next week with the recorded video and any presentation material. Up next, we have Water Quality, an Intersection of Science and Law with Anya Kwan, class of 17, on Tuesday, November 15th at 5 p.m. Pacific time. Also, if you're interested in being a Mud Talk speaker, please contact us at alumni@hmc.edu. All future events can be found on our website, alumni.hmc.edu. Have a great night, everyone. We'll see you next time.
Thank you, everyone.